Good morning, everybody. Thank you very much for joining us at this morning's webinar on new environmental duties imposed by the Environment Act 2021, or some of them at least. My name's Katherine Barnes. I'm one of the barristers here at 39, and I'm here with my colleague Stephanie David. So what we're going to do is talk you through, first of all, section 19 of the environment. I'm going to ask Steph some questions about that. Steph's the expert on that one. And then we'll do a swap, and Steph's going to ask me some questions about section 40 of the Natural Environment and Rural Communities Act 2006, but as amended by the Environment Act. Please do send us your questions through the Q&A function as we go along, and we'll try to answer as many of them as we can at the end. So without further ado, yes, I need to share the slides as Steph is just reminding me. Wall window. Great. So Steph, can you begin by setting out the context for this new duty?
Yes, of course. So the duty in many ways embodies one of the core environmental principles in and of itself. That is the integration principle, which requires that environmental protection is integrated into the making of policies. So that principle was an essential principle in EU law and was found in Article 11 of the Treaty on the Function of the European Union. And it was also alluded to in Article 191, subsection 2. Essentially, Article 11, which is, say, the key one, referred to it as follows, which is environmental protection requirements must be integrated into the definition and implementation of the Union's policies and activities. So in many ways, just pause there, go slightly further than just policy making, but also thinking about activities and how you implement the policies and activities. Article 1912 also sets out the other environmental principles. So the precautionary principle, the prevention principle, the rectification at source principle, and the polluter pays principle. And for those of you who have been following the kind of Brexit negotiations and legislation in the UK, you might be aware that section 16.1 of the EU Withdrawal Act from 2018 essentially required the Secretary of State to publish a draft bill. And that bill set up the Environment Act 2021. That bill, which was then enacted, required that the government put forward a set of environmental principles, along with a duty to publish a policy statement dealing with the interpretation of those principles, and further set out that there should be a duty to have regard to that statement when thinking about policy making. Just pause there. What is particularly interesting in my view is that actually section 16.2 specifically set out 9 principles. Of course, as we know now, only 5 made it into the Environment Act and then into the policy statement. So the set of principles that we're ultimately concerned with was then enshrined in section 17.5 of the Environment Act.
Right, so how does that context then tie to the UK's EU obligations?
So it's principally dealt with in the Trade and Cooperation Agreement. Chapter 7 addresses climate and the environment. Article 390 deals with the definition, so for example, environmental protection and what falls within that remit. And Article 391 is one of the kind of 2 key provisions for our purposes when thinking about this particular obligation. Article 391 is the non-regression from levels of protection, which you'll see there is on the slide. It's an interesting article because Article 391, subsection 1, essentially reaffirms the state parties' rights to set their own policies. So in many ways, it's a kind of assertion of at least the sovereignty of the UK, but also the sovereignty of the EU, insofar as that works in the kind of supranational context. And then subsection 2, that is the key point, really. So shall not weaken or reduce in a manner affecting trade or investment between the parties its environmental levels of protection. So again, that really is the key principle, also limited to the trade and investment. The other one is Article 393, which specifically requires the parties to respect the environmental principles set out in the international conventions. So the UNFCCC and also the Convention on Biological Diversity, and then also distilled in the Rio Declaration of 1992.
Right, so with that context in mind, what's the purpose of the policy statement?
So this is actually dealt with specifically in the Environment Act. If you look at section 17, subsection 2 to 4, it has really sort of, well, three main purposes in my view. The first one is that, you know, guidance around interpretation, so what do those principles actually mean?
Yeah.
The second is how they applied, but it's further than that, which is how they are proportionally applied in the context of policy making. And the third is emphasising that ministers looking at policy making still have to think about other factors that are relevant to a particular policy. And I know we'll turn to that point in due course. But taking that all together, I mean, there is sort of an element of circularity, because when you're looking at the integration principle itself, the statement had to indeed think about contributing to environmental protection and sustainable development.
Yeah. Which I suppose brings me on to the next question. What's a policy for the purpose of the policy statement?
So it's actually interesting looking at the policy statement itself, because it does say that it's a very, it's defined broadly, and it gives some specific examples, which is incredibly helpful for practitioners. So, for example, it includes proposals leading to legislation. It includes national policy statements. So again, obviously huge significance for infrastructure projects. Ministerial statements. And then it is also worth looking back at the Act itself. So section 47 actually defines policy, and it includes proposals for legislation, but again, for present purposes, this is important, it does not include administrative decisions, so decisions in individual cases. And the Act actually also defines making as well, which might seem potentially a little bit unnecessary, but it is helpful in terms of defining it as including developing, adopting, or revising policy. But again, just pause there. What the policy statement does make clear is that if you're looking at kind of minor changes, then it's unlikely to engage the duty, which makes sense from a kind of, you know, a materiality perspective.
Yeah, or maybe the way in which the duty applies is effectively going to be very light touch.
Yes.
So which brings us on perfectly to my next question. What does the duty require, Steph?
So it's essentially a procedural obligation. It's very much like the public sector equality duty, obviously using the words due regard. You'll see there 19.1 have due regard. What is interesting is if you trace this particular statutory provision through Parliament, you'll see that the duty was actually strengthened following review by the House of Commons Environment, Farming and Rural Affairs Committee on the 15th of October, because the previous wording had just referred to regard to the policy statement rather than due regard. It is then worthwhile kind of touching upon the case law on the public sector equality duty. One of the most recent considerations of that case is in the Court of Appeal decision of Webb and Harnden and Wolf and Forest London Borough Council, which was a decision from August this year. The reference is 2023 EWCA Civ 992. Paragraph 13, I mean, it doesn't really say anything particularly new. The two key points to draw from that case, in my view, is first of all, the duty is one of substance rather than form, which again is incredibly helpful when thinking about what the Section 19 obligation might look like and what it might require of ministers. And the second is really confirming that the judgment from Bracking is still good law, although slightly caveats the position insofar as saying that it should be treated like statute. But in terms of then Section 19 and the duty itself, obviously, as you'll see the provision on the slide, is subject to caveats, which we will come back to. The first one, so Section 19.2, as you'll see there, it refers to essentially whether there's no significant environmental benefit or would be in any other way disproportionate to the environmental benefit. I'm taking a step back. What that really is concerned with is the issue of proportionality, which is reflected in Section 17 as well, and was a requirement in respect of how the policy statement was designed. The second point is Section 19, subsection 3, which says the duty does not apply in those three areas there. So armed forces, defence and national security, taxation, spending, the allocation of resources within government, or Wales.
I want to ask you about that in a second, but it occurs to me we should probably just make clear that this duty is now in effect, isn't it? It's recently come into force. So it's not sort of on the horizon, waiting for regulations, are we? I believe it was start of November.
Yes, that's right. That's right.
And what you were talking about, this taxation exemption, that's potentially very broad. How do you think that will be interpreted?
Well, I think the explanatory notes are really helpful in that regard because it does make it clear that taxation refers to taxes in a legal sense. So what it doesn't therefore encompass is sort of other regulatory schemes where you're thinking about fees and charges, which is the most obvious in the context of looking at waste, the plastic bag regime, and other fees to cover the cost itself of the regulatory regime. And the other point that is worth flagging is, of course, spending all the allocation of resources within government is potentially hugely broad in terms of how it might be interpreted and could actually massively undermine the scope and ambit of section 19.1. But again, what's interesting is that the explanatory notes, along with the debates in Parliament, made it clear that what that is geared towards is essentially Her Majesty's Treasury looking at allocation of money as between departments. The expectation is when you're thinking about policy making itself, the policy will be designed by the relevant department, and then allocation of resources would be considered. So what that means is that by the point of time that you consider allocation of resources, the section 19.1 duty will have already been engaged, and they already will have had to comply with it. So the other reference to think about is, to say, I referred to debates in Parliament. So that's Minister Powell, who was the junior minister for DEFRA. And on 3rd of November 2020, she made it clear again that it isn't as broad as it might seem at first blush.
Yeah. Well, thank you very much. You certainly increased my understanding of the duty. It will be really interesting, I think, to see how it is applied in practice, because the public sector equality duty, my sense is that there was a sort of high point, and that since then the courts have really watered down what's actually required, and it's clearly very context specific. So it'll be interesting to see how that works for this duty, given the similarity, as you pointed out.
Yes, and I think the other point to add to that really is, whilst what you say entirely with regards to public sector equality duty, obviously it's some with protected characteristics, and they are concrete, black and white characteristics. Whereas in contrast, the environmental principles, and in many ways it's their greatest strength. They are very flexible, they depend upon the facts, and that could kind of lead to some difficulties in respect of how you ensure essentially some form of accountability in the courts. But it's certainly something to explore further.
Yeah, absolutely. Sounds like something that will be quite difficult to advise on, so we can look forward to that.
Right, so we'll move on to part 2 of our talk, which is the other statutory obligation. So this is section 40 of the Natural Environment and Rural Communities Act, as amended by section 102 of the Environment Act. So Katherine, can you remind us, firstly, what that specific statutory duty is used to provide for before it was amended by the Environment Act?
Yeah, I think that it's really important to draw that contrast, and I've set out on the slide the previous wording. This was up to 31st of December 2022, and you can see I've underlined the key part of the actual duty element. The public authority must, in exercising its functions, have regard, so far as is consistent with the proper exercise of those functions, to the purpose of conserving biodiversity.
And how was that interpreted?
Well, you can see, really, it was a standard have regard duty. As public lawyers, we're very used to those sorts of things. And a little bit, Steph, like you were just saying in relation to the new section 19 duty, there it's have due regard, so that's particularly important. But as you said, it is essentially a procedural requirement. It's not dictating a particular outcome. As long as account is taken, due regard is had, or in this case, merely regard. In theory, the public authority can make any decision that it wants to, and so that is, in a pretty standard way, how this duty was interpreted. There are various cases on it. I think it's pretty well understood how it applied. Cases like Bug Life and Suleiman made it clear that it applied whenever a public authority exercised its functions in a relevant way. So decisions like the grant of planning permission or publication of a new policy of relevance to biodiversity, those sorts of decisions would trigger the application of this duty. And then in contrast, see the case of Langton, for example, which is about a policy linked to badger culling. The duty is not going to bite in any meaningful way if it's not relevant to the exercise of the function. So if it's what's being decided is actually sufficiently removed, it's not really going to require anything in practice. So that's how it used to be interpreted.
And so the new version, so when did it come into force, and what exactly does it say?
So it came into force at the beginning of this year, 1st of January 2023. And as you said, Steph, it was, it was amended via section 102 of the Environment Act, but effectively that sounds like there was a bit of tinkering around the edges. The reality is that the duty has been replaced. There is now a new duty that replaces the old section 40. Apologies, the writing on the slide is tiny, but I felt I couldn't read, and I've already cut out some aspects of it, but it is quite a complicated provision, and I think I just wanted to flag really that when you in your practice are having to interpret and apply it, it is important to read it as a whole because there are lots of sort of different aspects to it. In broad summary, and I'll try and sort of give a high level view. As I understand it, there are two aspects to this new duty. So aspect 1 is in section 41, and that applies where there's a public authority with functions exercisable in relation to England. And it says they must, from time to time, consider what action the authority can properly take to further the general biodiversity objective. You can see I've underlined that. And then at the very beginning, we have a definition of the general biodiversity objective, which is the conservation and enhancement of biodiversity in England. And as we all know, this concept of enhancement, that was an addition to the statute, so in theory, a higher standard or at least a higher aspiration. So that's the first aspect. And then the second aspect is in section 41A. So once you've done the first bit, a public authority then has to determine such policies and specific objectives as it considers appropriate for taking action to further the general biodiversity objective, and then it has to take such action as it considers appropriate in light of those policies and objectives to further that objective. So it's quite complicated. As I understand it, there are 3 stages. Stage 1 is to do this review exercise or strategic assessment, if you like, so identifying action that the authority thinks it can take to further the biodiversity objective. So that is a sort of desktop exercise. Then stage 2 is for the public authority to develop policies to carry out those objectives that it identified at stage 1. And then stage 3 is to actually implement those policies that it's designed under stage 2, and to take action more generally to further the biodiversity objective as considered appropriate.
I mean, even looking at the statutory wording is quite interesting when you're thinking about that stage 2 point you made about essentially developing policies. The actual statutory provision doesn't go as far as to say as it considers necessary for taking action. It's as it considers appropriate for taking action, which again, it kind of waters down the obligation in some ways, and leaves it more so to the individual public authority's discretion in respect of, objective or policies it considers.
Yeah, it's giving with one hand and taking away with another, isn't it?
Yeah, absolutely. But so just those steps that you set out then, so when do those steps need to be carried out?
So the first stage, this strategic assessment, that's my wording, that's just my summary, that needs to be completed within 1 year of the new duty coming into force, so by the end of 2023. And then there has to be reconsideration at least every 5 years. And then aspect 2, so that's the design of the policies and their implementation, that's as soon as practicable after the completion of aspect 1. And I mean, just pausing there, maybe I'm being very negative about this, but I would be absolutely amazed if the vast majority of public authorities, I mean, when we consider how many bodies will count as public authorities, have completed that task. And again, not start the task, you've got to have completed it by the end of by the end of 2023. So I expect as well that it'll be very interesting to see what happens, and if maybe some kind of environmental organisation takes action to compel or at least speed up compliance with that duty.
Yeah, you're maybe saving it as a Christmas treat. I mean, it is interesting as well that obviously the public body is defined within the provision itself. So it isn't defined, for example, by reference to the Human Rights Act. What I thought was particularly interesting looking at it is that it does include HMR Treasury, Revenue and Customs, which is actually really quite interesting, particularly given that exemption in the context of the Section 9 duty, Section 19 duty. So yes, certainly interesting.
Yeah, I mean, I think the reality is certain public authorities, there's just, those that aren't sort of dealing with biodiversity issues. It's not, it's not really going to require very much, is it? It's going to be a bit of a sort of tick box exercise. But a lot of public, and then on the other side of the spectrum, there are public bodies that are dealing with the environment all of the time. But then there are lots in between where I think some of their functions will be have biodiversity implications. So yeah, a huge amount of work for our currently overstretched public bodies to be doing.
And just to pick up on one point, so obviously when you were looking at the kind of previous wording of statutory provision, you were talking about how it could be engaged in respect of particular decisions. And how does this new duty apply in the context of a specific decision?
Well, I think the reality is it doesn't, subject to what I'll come on to explain, it doesn't require anything in the context of specific decisions. My understanding is that it doesn't bite in relation to the exercise of functions in that way. And that's in contrast with the previous duty. You've obviously got to be very careful when looking at case law on the previous duty, not to just apply it across when the wording has changed so fundamentally. And in a nutshell, I think that's because the new Section 41 duty applies from time to time. That's explicit in the statute. And so it requires, as I described it, this strategic assessment. It's not every time the functions are exercised, it's from time to time. And then the subsequent Section 41A duty flows from that strategic assessment and whatever was decided under that. And of course, as the statute makes explicit, the public authority can legitimately decide, as long as it's rational, that actually there's nothing that they should be doing to further the biodiversity objective. So yeah. The caveat to that, by which I mean this general principle that the duty doesn't bite on specific decisions, is that obviously it depends how the public authority in question has gone about complying with the Section 41 and Section 41A duty. Because if they introduce policies that then do bite on individual decisions, as one would expect many public bodies will do in due course, then of course they've got to act in a manner consistently with those policies, unless they're departing with them for good reason. So, slightly nuanced answer, I suppose.
And just in terms of amendments to, there's no authority on the new Section 40 duty and how it applies to individuals. So how can we be certain that's the right approach?
Well, look, we can't be absolutely certain because we don't have a reported court decision on it yet, but I think it's pretty clear from the language of the new Section 40 when you read it carefully. I mean, particularly this from time to time makes it, to my mind, pretty clear. We're not talking about the old duty applying every time a decision is made. But also, if there were any doubt, look at the explanatory notes to Section 102 of the Environment Act. That makes the change of approach explicit. And I've set out a little chunk from the explanatory notes on that slide. But you can see, so new subsection 41, a public authority must periodically consider the opportunities available to improve biodiversity across the full range of its functions. this represents a proactive strategic assessment of a public authority's functions rather than considering each function in isolation as required by the original Section 40 duty. So I think it's pretty clear from that what was intended, and that, to my mind, reflects the language that has been used and that was approved by Parliament. The other thing worth mentioning, it's not a reported decision, but I was involved in a commission hearing a couple of weeks ago, it was before His Honour Judge Jarman, and he accepted the argument that we were making for the interested party and that the defendant counsel were making, which is precisely what I've just outlined, that Section 40 doesn't bite on individual decision. In that particular case, it was a decision to discharge a planning condition. Several people have asked me for a copy of the judgment. I'm afraid there isn't one because it was given in an extemporary way, but further confirmation, there is at least one judge who agrees that that's the right approach.
And just taking a step back from all this, I mean, do you think this, as you say, essentially this new duty is ultimately, do you think it ultimately enhances or do you think it dilutes environmental protection?
Well, I think it's probably too early to tell, which is a bit of a cop-out. On the one hand, you could see it as a weakening of environmental protection because there's now no specific obligation that bites on individual decision making. So, when the hard decisions have to be made, there's no longer a requirement to have regard to biodiversity. But that said, how effective was the original Section 40 duty anyway? In many contexts, policy will require a decision maker to have regard to biodiversity anyway. I have to say, I can't, in my practice, think of many cases where having regard to Section 40 made a material difference to the outcome. Indeed, I've seen quite a lot of officers' reports where, a bit like the public sector equality duty, there's a sort of pro forma copy and paste jobbing that's done that just says, oh, we've had regard to this duty. So it seems to have become a bit of a box ticking exercise. And I suppose if this new exercise is carried out conscientiously and in good faith, it could really make a difference. And obviously the way it affects different authorities will depend on the approach that they take and on the nature of their functions. But I suppose the point is that it requires a lot of goodwill and cooperation on the part of the authorities. So a public authority that takes environmental protection very seriously, wants to set itself ambitious targets, goodness, this could make a massive difference. But a public authority that frankly just wants to do the bare minimum can, I would suggest, get away with doing, well, I mean, literally nothing in some cases, and in other cases, almost nothing.
I mean, just 2 points from that. I mean, the first one is, as I said, kind of conscientiously considering it. I mean, it is, as a case law on the PSED is clear, it is a duty of substance, not just form.
Yeah.
And therefore, I think that the courts would be reluctant to accept consideration of that duty that solely is a box-ticking exercise. I think the other point is point regarding guidance. I mean, what is interesting is the statute provision specifically says that the government will produce guidance, and helpfully they have a 2-year time frame for producing that guidance from the date that it came into force. So that obviously leaves public authority slightly in the lurch, but we'll see how ultimately that pans out. So I think we have some time for some questions now.
Yes. One thing I wanted to ask you, Steph, because I think it's pretty critical, and we started talking about it, but I'm sure you've had more thoughts. How do you think the Section 19 duty will be interpreted in practice? And to what extent will it make a difference?
So I'm going to answer that second part of your question first. In terms of how much it will make a difference, I mean, I think the starting point is that these environmental principles should, in theory, be at the forefront of people's minds. So that's obviously incredibly important when you're thinking about policy making, because of that particular duty in statute to have regard. I think that does make a difference because, I mean, whilst these environmental principles aren't new, they're very much part and parcel of EU law, and they have informed the protection of habitats and the protection of environments. It is quite different when you have, in many ways, a kind of, a black and white duty in statute. But against that, tied to the point I made earlier, what I think is particularly difficult is the statutory provisions underpinning the policy statement and the policy statement itself essentially make it clear that the principles must be applied proportionately. And in many ways, that is a kind of new element to how you consider these principles, which in some ways are, particularly under EU law, for example, are clearer in what they require. So the most obvious one is the precautionary principle. Going back to the Trade and Cooperation Agreement, in that agreement, it specifically defines the precautionary principle without consideration of costs. Whereas actually, when you look at how it's defined in the policy statement, cost is a very big element in respect of how you approach the precautionary principle. So the long and short of that is, on the one hand, it is a statutory duty, but on the other hand, given the very nature of environmental principles, particularly given how they've potentially been approached in the policy statement, there is a risk that it comes down to essentially what ministers normally do when looking at policy making, looking at that kind of balancing of different considerations, obviously in respect of which the courts would defer quite significantly.
Yeah, I wonder if a bit like the public sector equality duty, there will be a sort of high point of the duty, some initial challenges, and particularly while public bodies perhaps are still finding their feet, and particularly the public bodies where biodiversity is not at the centre of what they do, may well not be completely au fait with what they're required to do. But then as time gets on and it becomes more embedded, whether there's sort of then a bit of a decline, we'll have to see.
Yes, I mean, there is a kind of one important kind of distinction really as between the Section 19 and the Section 40. Section 19 really is a duty principally on central government because it's on the Minister of the Crown, whereas Section 40 is concerned kind of more generally with public authorities. So also the targets will be slightly different. But anyway, in terms of the Section 40 duty, I mean, where do you see the potential legal challenges?
Well, I think a really obvious one is for completion of the strategic assessment, the sort of stage. I outlined that there were 3 stages, if you like, to stage 1, and we're almost at the end of 2023, and I would be amazed if, frankly, the vast majority of public authorities had done it. So I think that might be the first sort of stage of litigation, and it's not very, on the face of it anyway, particularly difficult given that the statute specifies when it has to be done by. And then, of course, as we go forward, I think, and once public authorities have done their strategic assessment, they've introduced their policies, then I think we're probably looking at challenges to specific decisions which allege that public authorities haven't applied their own policies correctly. But I don't think we're probably at that stage yet, because, and again, maybe I'm just being excessively pessimistic here, but I just don't think many public authorities will have a properly worked up suite of policies at this point. But in theory, well, the law requires them to by the end of the year. So, not to have a fully worked up set of policies by the end of the year, but it's exactly and as soon as practicable afterwards. So watch this space. I think that could give rise to some really interesting litigation.
So there's one question that we've been asked as well about the fact that the duty goes further, just conserving and includes enhancing. And again, that is interesting when you're thinking about the Environment Act as it was going through Parliament, when it was the Environment Bill, and also thinking more generally about a drive towards essentially a nature positive economy. So thinking about the response to desk crypto review and things. I mean, this notion of enhancing. Yeah. I mean, that's a really interesting point. I mean, do you have any views on that particular word and how it might be approached?
I do, and someone has flagged an insightful comment that Wales, their duty used the wording maintain and enhance, and apparently that's worked quite well there. But I think it comes back to the answer I gave you earlier, Steph, which is that it really depends on the goodwill of the public authorities, because I don't actually think the duty imposes anything particularly difficult or high level or extensive on public authorities. They have a lot of discretion as to how they comply with it. So if they want to take it really seriously, then they've got the tools to do so. But equally, if they don't and they just want to do the bare minimum, I think it would be very difficult for somebody, assuming they've written the decision properly and taken legal advice, I think it would be difficult for someone to then challenge it on this basis.
Just one point to pick up on that. Just again thinking about how it would apply to essentially kind of central government, obviously bearing in mind the other targets under the Environment Act, the most obvious one being the species abundance target. I mean, it'll be interesting to see how they fit together in due course, because I mean there is an element of these kind of various duties dealing with similar issues. There's kind of that intersection between them all. So I think there's something to be worked out there, and maybe by virtue of having those further duties or targets on central government, more will be expected. But I mean, it's certainly something that could be worked out in due course.
Yeah, absolutely. I think there's a sort of major overlap, isn't there? And I think those specific targets are effectively then become minimum requirements under Section 40 as well, for certain public authorities like the government, like you say. But the extent to which that then filters out to other public authorities, we'll have to see. Another question I think that, Steph, you're best placed to answer because it relates to Section 19. Somebody's asked the difference between having due regard and merely having regard. I think it's a good question.
Yeah, it's
what
a
do you
very
think?
good question, and it's a really important question, particularly in the context of Section 19, because it was an amendment made as the provision was going through Parliament. So it was have regard, and it was changed to have due regard. Due essentially puts greater emphasis on having regard. It emphasises the importance of that procedural obligation. Whereas have regard is simply take it into account. You can take something into account and you're entitled to give it no or very limited weight. And that's all you have to do. Whereas due regard, kind of about the point that you made earlier, is that conscientious consideration, thinking about it carefully. What does it really mean for the particular policy that I'm looking at? So there is a difference there.
Yeah, absolutely. But again, we'll have to see how the courts approach it, because, well, as somebody who's tried to bring many public sector equality duty challenges, I think it's fair to say there's an element of subjectivity, isn't there?
Yes.
It depends on the judge, and certain judges, any mention of the section duties being discharged as far as they're concerned, and others will really, in quite a forensic way, look at the decision-making process and kind of, really, as you say, make sure that there was regarding substance, that due element carries its weight. Well, thank you very much for joining us. I think, everybody's got busy days, so we'll leave you to get on with your actual work. But it was a pleasure conversing with you, Steph, so thanks very much. And we look forward to seeing you at another 39 webinar in the not so distant future. Goodbye, everybody.